So good afternoon, everyone, and welcome to the third Parker Bullen webinar. Today, we will be presenting on the importance of having a shareholders agreement. So I hope you're all well, and thank you very much for taking time out of your busy day to join us. It's great to see so many of you attending and supporting our webinar programme. My name is Molly Dilling, and I will be the host for the short webinar. So my job for today is just to push the right buttons, ask any questions that you may have, and to generally keep things on track. So the way that we will go today is just an informal chatty style webinar, so please get involved and ask any questions that you may have. You can do this by using the questions button. You are able to type in any questions that you will have, and we will try and cover as many of these as possible, either during or at the end of the presentation. So before I hand over to today's presenters, just a couple of housekeeping points. So the intention is that the webinar will run for 20 minutes, but depending on how many questions that we have, may run up to 30 minutes. So this webinar is being recorded, so the link will be shared afterwards should you wish to rewatch it or share it with any other of your friends or family. So we will also have a summary handout which will be sent to any attendees at the end after the webinar. So the purpose of the webinar today is for us to share some useful information, practical tips and guidance on the topic of shareholders agreements. Just as a disclaimer, any advice that is given in this webinar is generic and it should not be relied upon unless you have spoken to us separately and we have provided you with advice that is pertinent to your individual circumstances. So in today's webinar, we'll be talking about the importance of having a shareholders agreement. And to present the topic, I would like to hand over today to our presenters. We've got Leah Horton, who is a solicitor in the commercial department, and Ketan Patel, who is a trainee solicitor in the same team. So over to you, Leah and Ketan.
Excellent. Thank you very much, Molly, for that excellent intro. So good afternoon, everybody, and thank you for joining us this afternoon. Leah and I are here today to offer you a brief guide into the topic of shareholders agreements. And we will do this really by firstly explaining briefly what shareholders agreements are, and then we will be discussing the relationship between shareholders agreements and the company's articles of association. And I'll come on to how important that is in a moment. But after discussing both of those points, Leah is going to take you through a series of fictional scenarios, which will explain how having a shareholders agreement in place can benefit the shareholders described in that given scenario. So the key question for today really is, wouldn't it be helpful to shareholders if they could pre-agree how certain events will be governed before they arise in order to avoid disputes between the shareholders, protect the shareholders' interests, and ensure business continuity? That's the question I wanted. Sorry for that small glitch on the slide there. So we hope that by the end of this webinar, you will agree with us that entering into the shareholders' agreement can actually to the shareholders of the company, and that's what we want to try and help everyone understand today. So let's ask the first question then, which is, what is a shareholders agreement? Well, put simply, a shareholders agreement is a contract between the shareholders of a company and potentially the company itself. Such an agreement can be used to govern the management and the affairs of a company privately. And essentially, a shareholders agreement is a contract. So if one shareholder doesn't comply with one of the provisions in the agreement, then another shareholder could potentially sue their co-shareholder or indeed the company for breach of contract and potentially then claim damages for any loss suffered as a result of that breach of contract. And there's one key trait to shareholders agreement, and that is that they are private. So unlike other information, they're not publicly available through a company's profile on Companies House, unless, of course, the shareholders decide to put it out into the public domain, which indeed is very rare. So we will come on to the benefits of shareholders agreements in a moment. Before we do, let's explore one of the key considerations that shareholders should consider before putting an agreement between themselves in place. And that key consideration that I'm referring to is, of course, a company's articles of association. So what are a company's articles of association? Well, they form part of a company's constitution, and the articles themselves dictate how the company is managed. For example, how board meetings and general meetings are held, and even how directors and shareholders can make decisions in the company. And in contrast to a shareholders agreement, articles are public, so they can be viewed on a company's profile at Companies House. And really, another crucial point or key trait of articles really is that articles are compulsory for private limited companies in England and Wales. And when a company is incorporated, if the shareholders do not adopt their own articles, then the company will automatically adopt a set of articles known as model articles, which are the default articles set out by law. And often is the case that the model articles may not accurately reflect the way in which the company's affairs are managed. And therefore, in such circumstances where there are model articles, it's worth adopting bespoke or custom articles of association, and especially so if the shareholders are looking to enter into a shareholders agreement. So why should the company's articles be considered when a shareholders agreement is agreed between shareholders? Well, as we've discovered so far, both a shareholders agreement and the company's articles play a role in governing how a company operates. So it naturally flows, and indeed it's sensible really, for a shareholders agreement and the articles of association of a company to be considered and drafted together, so that the provisions in the articles of association are compatible with the provisions in a shareholders agreement. And of course, one of the underlying principles of a shareholders agreement is, of course, to prevent disputes between shareholders in a company. And so the provisions in a shareholders agreement should not conflict with the provisions in a company's articles of association and vice versa. And this is sort of, I'll try to demonstrate it on screen here with our sort of very simple but quite effective graphic on screen. The article should work in tandem with a shareholders agreement, and that really is the key point. And finally, actually, on this particular point, it's worth noting that the remedy that is available for a breach of a provision in a shareholders agreement may well be different to a remedy that would be available to someone if a company had breached an article. So that's really another reason why companies' articles should be, at the very least, be looked at when shareholders are looking to enter into a shareholders agreement. So now let's turn to the real benefits of having a shareholders agreement in place. And Leah's going to take us through some scenarios. So Leah, over to you.
Thank you, Caton. I'm Leah, and I'm a solicitor working in corporate in the commercial department at Parker Bullen, as Molly already said. So far, we've considered what a shareholders agreement is, what the articles of association of a company are, and also the importance of the relationship between those two documents. So, as Caton already mentioned, we're going to go through some fictional scenarios to focus on the benefits of shareholders agreement or bespoke articles. So the first scenario, as I say, these are fictional, companies aren't real. ABC Limited is a company with two shareholders, each holding one ordinary share in the company. So they have a 50% shareholding each. So this is a typical scenario for owner-managed businesses where there are two shareholders, where they may be family members, for example, and where those shareholders are also the two directors of the company. So where there are two shareholders with equal shareholdings, there's a risk of a deadlock situation arising when the shareholders are trying to make decisions if they don't agree, because nobody has a majority. So obviously a decision can't be made. So in this scenario, a shareholders agreement can assist with a company with similar shareholdings, as it can set out deadlock resolution procedure if a deadlock situation occurs. And as an example, this could involve one party selling its shares to the other party. So essentially then there's only one shareholder who is left to freely make the decisions. So we can see that a shareholders agreement is quite important where there are two 50% shareholders, as if there's a disagreement in relation to the management of the business, this could lead to significant demotivation by either or of the director shareholders, but also it could cause delays in important decisions being made. So if we now go on to our second scenario, XYZ Limited is a company with 5 shareholders and share capital of 100 ordinary shares. So shareholder 1 has 55 of those shares, shareholder 2, 20, shareholders 3 and 4 have 10 shares, and then we have shareholder 5 holding 5 shares. So with this company, shareholder 1 holds a sufficient percentage of shares to be able to pass or block ordinary resolutions of the shareholders on its own. So for an ordinary resolution, you need a simple majority of the shareholders. Shareholder 1 can also pass special resolutions, which is a shareholder resolution passed by not less than 75%, if they also have shareholder 2 agreeing with them, or if they also have shareholders 3 and 4 agreeing with them. So clearly, shareholder 1 holds significant voting power here, whereas shareholder 5 has little sway in decision making. Whereas under the Companies Act, shareholder decisions can be passed by the simple majority, so ordinary resolution or special resolution, not less than 75%, depending on what that decision is. Under a shareholders agreement, the parties can agree that certain matters will only be decided upon with a certain percentage of the shareholders consenting to that decision. So in this scenario, to help shareholder 5 and protect shareholder 5, it could be agreed that certain decisions would only be made with the consent of all of the shareholders. So essentially you vary those percentages which are set out in the Companies Act. An example of decision that could require 100% shareholder consent under the shareholders agreement could be that the company won't issue any new shares to new shareholders unless 100% shareholder consent is first obtained. So this sort of provision has the benefit of ensuring that unless all the shareholders agree, their shareholdings won't be diluted by the issue of further shares in the company. So if we go on to the next scenario, this follows on from the facts of scenario 2. So the shareholders have the same percentages of the shares in the company. But in this scenario, so shareholder 1 and shareholders 2 want to sell their shares in XYZ Limited to a corporate buyer, ABC Limited. ABC Limited wants to purchase the entire issued share capital in the company, but shareholders 3, 4 and 5 do not want to sell their shares. So in this scenario, it would be really helpful if a shareholders agreement pre-existed this potential share sale, as it would assist shareholders 1 and 2 if they had pre-agreed drag-along provisions, which have in the articles and or the shareholders agreement. And drag-along provisions are rights for the majority of the shareholders, typically over 75% of the nominal value, to accept an offer to purchase their shares. And that right also requires the shareholders of the remaining 25% to also accept that offer. So this provides protection for the majority shareholders in this scenario, shareholders 1 and 2, that they'll be able to secure an exit and realise their investment in the company by requiring those minority shareholders to agree to a share sale in the future. And often with drag-along provisions, there are tag-along provisions, which are essentially the equivalent right for the minority shareholders to tag along to a share sale by the majority shareholders. So our fourth scenario, same facts again. Shareholder 2 of XYZ Limited is a director and employee of the company, but wishes to resign. So it's quite common to have a procedure in a shareholders agreement relating to the transfer of shares. And the starting point can be stated that no shares will be transferred unless the provisions of the shareholders agreement are complied with. So in this scenario, the shareholders may not want a former director and employee to remain as a shareholder of the company when they're no longer a director and employee, and therefore it'd be helpful if the shareholders agreement that had already been entered into or the company's articles contained compulsory transfer provisions, which would essentially require the shareholder to transfer his shares in certain circumstances, one of which could be where the shareholder's employment and or office as a director is terminated, as is the case here. The issue here is if the compulsory transfer provisions are not included in an articles or shareholders agreement, and shareholder 2 resigns, he or she would remain a shareholder benefiting from, well, provided his shares have this right, dividends declared, without actually contributing to the business anymore. So this is often a problem for owner-managed businesses, and where, you know, everyone who's a shareholder is an employee and director, so they're contributing to the business. But what happens when that person's no longer an employee and director, and actually they're not contributing to the business anymore? So if at that point, if the agreement's not in place, it's not until they're leaving the company that an agreement would have to be met as to whether the company will buy back the shares or whether another shareholder will purchase the shares off the exiting shareholder, and how their shares will be valued, what the price of those shares will be. This can be a bit of a contentious issue if the parties are quite far apart, obviously, on how they're valuing the shares. It's also possible to have good and bad leaver provisions included, so that essentially a bad leaver, when they're exiting the company, receives less for his shares than if he was a good leaver. So if someone leaves because they're retiring, they've been made redundant, or if they've died, they'd generally be classed as a good leaver, depending on how that's defined in the relevant agreement or articles, versus a bad leaver, which would generally be someone who's not a good leaver. Or so I suppose in this, with that kind of definition, it would be someone who's resigning and leaving the company. So our final scenario is Bonjour Fresh Limited is a company providing an ingredient and recipe subscription service. It's a fairly new concept which has seen high demand and growth during lockdown, and there are lots of new entrants to the market. Its shareholders are not all directors of the company. So with this example, we have a company in a highly competitive and innovative market. So it will obviously want to protect its new ideas, confidential information, and be protected if a shareholder leaves the company. If the shareholder in this case was a director as well, they may have entered into a director's service contract, which may already have restrictions on the director employee and what they can do. But if not, you can include, as in this scenario, they're just a shareholder. You could include restrictive covenants in a shareholders agreement to restrict the activities of the shareholders. So essentially, the shareholders promise to each other that they won't be involved in a competing business in any capacity, so as an employee, shareholder, consultant, director, whilst they're a shareholder of the company. So this assists in circumstances such as this, where some of the shareholders are not also directors, particularly as directors owe fiduciary duties to the company. And so if they are also working for a competing business, or let loose some confidential information, they'd likely be in breach of their duty to act in the best interests of that company. But shareholders aren't subject to those duties, so there's nothing to restrict them from working in a competing business if they're not also a director. So I'll now pass back to Caton, who's going to summarise what we've discussed. Thanks very much.
Thank you very much, Leah. So in summary then, here are today's key points. Shareholders agreements are really beneficial where there's more than one shareholder, and we saw that from the scenario 1 where we had a deadlock scenario that could arise. Shareholders agreements are also private documents, as I've said a few times already today, and they're pre-agreed at an amicable stage. So realistically, that means that they're a sort of sensible safeguard, a prudent safeguard against any potential future issues that may arise. They can provide protection for majority and minority shareholders, and they can also restrict shareholder activities, as we saw in our final scenario there. And really, on a practical level, they encourage discussions between the shareholders on agreeable and acceptable terms in relation to their company matters. And on that point, actually, sometimes, and I think some of us here at Parker Bullen have seen it, that you often get scenarios where shareholders who are looking to go into business together think about these matters before they do so, and they find that actually after discussing them, they realize that actually they might not work together well in business, so they've sort of tend to back out of it. So it can be really valuable to think about it even before you look to purchase shares or get involved in a business, indeed. And finally, really, forward planning can be favourable with lenders, financiers, insurers and investors. And so if a company is looking to, or if shareholders foresee a company looking to go down one of those avenues, for example, get some money, borrow some money, then it can definitely be beneficial to have a shareholders agreement in place, because it shows the banks, the insurers, etc., that the shareholders are being cautious and they've got something in place should they end up in any disputes in the future. And really, finally, as I've said a few times, the terms of a shareholders agreement should work harmoniously with the company's articles. So we hope you found this webinar useful, and it's given you a good insight into the importance of shareholders agreements. Just to say really that it's important for shareholders to seek legal advice before putting an agreement in place. Agreements themselves are not a one-size-fits-all. Terms will vary and be different depending on a company's structure, a company's size, its industry, etc., and its plans, and of course, its shareholders and their respective shares. And at Parker Bullen, we've got the experts who can provide you with that sort of tailored and expert advice whilst minimally disrupting your business operation. So do bear this in mind if you're looking to put one in place. Thank you very much. I hope you found that interesting. And I'll hand back to Molly.
Thank you, Kate and Leah, for a very informative presentation and very engaging as well. We have got a few questions for you, if that's all right. So we've got a question from Joe, and Joe has asked, what happens if there is a new shareholder who enters into the company after the agreement has been entered into? Are they automatically bound by the existing shareholders agreement?
Are you happy for me to take that one, Leah?
Yeah.
Okay, so a company, so if you've got a new shareholder that's going to enter into the company and there's already a shareholders agreement in place, that new shareholder who comes in won't automatically be bound by the agreement, no. But having said that, they could be bound to it. So annexed to a shareholders agreement, you will often find something called a deed of adherence, which is for use when a new shareholder comes into the company or would like to be as part of the agreement. And of course, a usual circumstance in which you would expect there to be a new shareholder would be if one shareholder is transferring their shares to another shareholder. So an existing shareholder is transferring their shares to somebody else, and that other person needs to be bound by the agreement. And so in such a circumstance, you could make it a condition of the share transfer that they sign a deed of adherence, which would bind that new shareholder into the agreement. So there is always a tool there that's usually attached to it, which would enable a shareholder to be bound into the agreement, but naturally they're not automatically bound.
Thank you for that, Kate. And we are running out of time, unfortunately, but I just do have another question for you. Tim has asked a very, very interesting question. He says, our company has model articles of association. What do we need to do if we would like bespoke articles?
Hi, Tim. I would just say that obviously we'd love to help you if you need help with drafting your bespoke articles of association, but it's quite a simple process, really. you'll obviously be adopting new articles, so there needs to be a shareholders' decision to adopt those, and that needs to be a special resolution, so at least 75% or not less than 75%. And then those articles and the resolution will be sent to Companies House for filing.
Thank you, Leah. That's really helpful. So unfortunately, we have now come to the end of the webinar. So I just like to say a big thank you to Caton and Leah, who are presenters today, for a very engaging and informative webinar. And also thank you to all our attendees for taking the time out this afternoon to support Parker Berlin and attend our webinar. So as I said at the start, there will be a link sent to the recording of this webinar and also a summary handout. If you have any queries about anything you've discussed, or if you would like any tailored advice in relation to your company on the topics covered, please do get in touch. You'll see Leah and Kate's emails on the screen now. So yeah, thank you from me and enjoy the rest of your day. Thank you.
Thank you very much.
Thank you.